Okay, hello and welcome to a little YouTube video that we're doing on a problem-solving assessment task that we did recently in Contracts 2 at the University of Newcastle. So this was a little bit different than your standard problem-solving question, and many students out there would be familiar with the IRAC, or Issue, Rule, Apply, Conclude method of solving legal problems. And I've been talking to my peers about the idea of moving students beyond IRAC to a problem-solving technique that is that I discovered that's in a little book called Getting to Maybe. And the idea is to have students think beyond the fact that there is one way of solving a problem, to think that there might be many different ways of solving a problem. So the problem question that was set for the students this year was, it covered specific topics. It was the first 4 weeks of class this semester and the first 3 topics. We started with estoppel, we looked at illegality, and then we looked at privity. So the question had elements of each of those 3 topics in it, and it involved our client, who was Phoebe, who was the owner of a business. So the business was really the client, and it was a proprietary limited company called Smart Dresser. And Smart Dresser had decided to move her business to a new area because she was worried about competition. She was in Charlestown, for those of you that are familiar with Lake Macquarie. And she moved her shop, which was a menswear shop, to Valentine, to a shopping mall. And what she did was she bought the business of somebody that she knew that already had a menswear business and was thinking about retiring. So she had a couple of different transactions. One was with the business owner that she was purchasing the business from to relocate her business. And the other one was with the owner of the shopping mall. And the issues that she had with each of those people was a little bit different. The issue that she had with the previous owner involved a deal that they'd struck regarding the way they'd structured the purchase of the property. And part of the deal was that the previous owner would come back and work in the business for a period of time, and that was taken into account in the purchase price, because he didn't want to receive the full purchase price because he was worried about its impact on his pension, and his partner was unwell and was claiming some sort of social security department, the healthcare card. So when he got sick, his partner now wants to claim a termination payment that was part of that arrangement. And so we have a privity question to deal with there. That was the primary question. The relationship with the owner of the shopping plaza, who was now the landlord, involved an estoppel issue. And that was to do with a conversation, a pre-contractual conversation that they had about exclusivity. So that particular issue mainly focused on estoppel. So we primarily had a privity question and an estoppel question. But there were sub-issues branching off both of those 2 main issues. So the students knew that they had the topic areas that they had. So they didn't have to worry about identifying the core issues. They were given 2 issues. I think they're here on this PowerPoint slide. So the first issue was Stuart's claim under the informal agreement. That was the privity issue. The second one was Phoebe's reliance on representations, and that was the estoppel issue. But of course, the topic of illegality may have come into the first issue, and the second issue mainly involved estoppel. Anyway, the idea was that students, rather than falling back on the old IRAC method, would use a mind map to tease out the issues. And most importantly, what I was really trying to get them to do was to think about the sub-issues and the way they might argue them. So the argument, counter-argument approach, that your client might have an argument, but the other side might also have a counter argument. So you would be concerned as their lawyer that if that was a good counter argument, you might need a backup argument. So that's the gist of the assessment task using a mind map. And I'm going to hand over to my two amazing law students here, Olivia and Emily, who both did very well in this assessment task. And they're going to tell us a little bit about their approach to using mind mapping for legal problem solving. So just bear with me a minute, and I'm going to change the share. I'm hoping. I'm hoping, is that right, Emily? Have we got your, yeah. So Emily's going to tell us a little bit about her response to the question, but mainly about how she tackled legal problem solving in this particular task.
Yeah, I think with this question, the first thing I kind of wanted to do was like start making the mind map, but I realized really quickly that if you start, especially with this type of thing, if you start putting ideas down, you kind of get lost in translation. You start having all these different thoughts. And so I kind of had to first sit and really read through the question and nut out like the areas that I thought there was some issues. And obviously, as you said in this question, we had a predominant issue that we were looking at, but there was the opportunity to explore some alternate ones. So I had to kind of like really read the question and have a good understanding of the law and what kind of things I was looking for before trying to tackle it, because especially in this instance, you just start writing and you kind of lose track of where you're actually going. And so I think in that first pink box, I talk about like who our client is, because for me, sometimes it can be really difficult if I start with the law in a problem question, because I don't really know like always what's going on. So I find it better to maybe look at like what our client wants, and then from there work out, okay, well, what legal tools can help me get there. And so I worked out that in this instance, I was looking at that Stuart wanted to get the payment. So it was like the third party issue, that this one you can see. And so if you scroll down a little bit, yeah, there we go. I was a bit confused as to how to display it in a way that made sense. You don't want to like write heaps and heaps in those little bubbles, because then it just becomes a bit chaotic. And so I used color a little bit, which I thought was kind of fun, a bit different. And I used like colors depending on whether I thought it was a viable argument or whether I thought it was like a counter argument that was there and that was still worth mentioning, but that wasn't probably the path that was going to happen. And so I think when you're doing these things, it's really important to kind of straight away say what you're doing. So for example, where I've said illegal, I've straight up said like likely no. So yeah, there's something here and maybe it's worth mentioning to show that I've considered the problem, but I don't think it's a path that is worth following with a lot of effort, because I guess as a lawyer, you want to kind of present to your client all of the available options, but address the ones that are the most viable. And the same thing was with the issue of consideration that we had here, because there was a bit of an issue with, I can't even still receive 10,000 per year. Yeah, because they were basically, it was a weird agreement. It was like an agreement that they were agreeing to do some work for each other, but even if he didn't do the work, he would still get the money. And so I kind of raised, well, maybe there's a consideration issue, but in this case, I didn't really think it was worth following further. So again, just kind of getting to the point really quickly. You could ramble on for ages about that, but that's not going to help. And as a marker, I know that if you're reading it, you're like, where's she going with this? So you want to kind of be really quick and like smart with it. And I think for me during this assessment, one of the things I did a lot was go back to this top and read it through and keep going back and being like, okay, well, if I was reading for this for the first time, would I understand where I was going and would it make sense to me? Because you can start to like have 1,000 boxes and know where to go, like no flow, if that makes sense.
Absolutely.
Yeah. And then I'm trying to think of what else I did that was different. I think in using like case law and things like that, just being really concise about where you're getting it from, just using a pinpoint and making it really clear, and applying it to the law. So not just, I think sometimes we can state a rule and then just kind of like leave it hanging. But it's really important to like say, yeah, that applies here and here's why, and doing that really quickly. I think in that no box that you've got, that's what I've done there.
Yeah. So you can see my mouse. That's good.
Yes. Yeah, I can see your mouse. Yeah.
Great. Oh, that's great. I was hoping you could. Yeah. No, that's exactly right. That's really cool. So there's your pinpoint reference.
yeah, that
how it
joint
applies.
primacy.
Yeah.
Yeah, that joint primacy on, I remember being like, okay, like here's an argument, but I don't think it's viable, and here's why. Yeah, if that makes sense.
And you've got a bit
And
more up
then,
here.
yeah, yeah.
Yeah.
Yeah, just using really simple gems and rules and things like that.
Yeah.
And what else have we got? I think, I was really the facts of, sometimes I find it difficult, especially if you're using lower court judgments. When you're using them, there's a tendency to just like take the rule that they've taken from a higher court case and quote it, which is fine. Like that's a fine way to use a case. But I think sometimes it can be better to use like the facts of the case so that you get you're able to say like, this is actually kind of similar. And in this case, a judge with great experience, whatever, found so, and so we should do the same thing here. And that's what I did, I think, with Mizzy, because I thought it was quite similar, or there was an argument at least that it was similar. And so, I think that's an important thing when you're reading cases, is to be looking for those similar facts so that you can kind of apply them and work with them. And then, I had another counter argument, which again, I think it's important if they're there, like you need to acknowledge them. I know sometimes I was definitely earlier on in like first and second year, I had a tendency, if I was meant to be arguing for one person, to only want to argue the things that were going to get them there. But as a lawyer, you need to acknowledge like the other side, and a good problem question should acknowledge the other side. And that's not bad. That's not showing your weaknesses. Like you need to acknowledge those to get yourself there, if that makes sense.
You need to anticipate, because
exactly.
That's what's going to happen to you when you get in the courtroom. And if you imagine that it's all going to be clean sailing or smooth sailing, that's going to unravel you when you get to court. But if you've anticipated that there's going to be something thrown out at you, and you've already thought about how you might respond, which might be, oh, well, that's going to be a really good argument and I'm going to have difficulty knocking it over, or that won't be such a strong argument because I can knock it over with this counter argument. Yeah.
I think if like you can beat yourself, then you're doing well, if that makes sense. And I always think if the best way to be is to be able to understand the side of the other side, what they're going to come at you, and then be able to counteract that. Which in this one, there was a lot of kind of different arguments and lots of different things. So just keeping it kind of simple, using the headings as questions. I think I did a lot, like that joint primacy ? So that I wasn't wasting words explaining what I was arguing in that box, just getting straight to the point.
Yeah, no, that's terrific. And I think this idea of putting questions in the box is really helpful for the marker, because it's about being able to follow where you're going. Is such a big thing with these mind maps. It's like, where are you going with this? So where are the signposts? That's what I was often looking for. That's fantastic. Thank you so much. I'm going to stop and pull up Olivia's now, because we're just doing this fairly quickly. Okay. Okay, so hopefully, Olivia, yours is up there now, is it?
Yeah, it is.
Okay, and I've got my little pointer here, so you can take me places and I'll point.
Sure, okay. I think my approach to this task, just listening to Emily explain her thoughts then, there was a lot of similarities actually. The first thing, I thought I was a little bit intimidated by the mind map as well, because it's just, I feel like you can get lost in it. So I kind of ignored the whole Padlet like mind map for a while. I was like, I'm going to figure this out as a scaffold in a Word document, because that's something I'm a bit more familiar with. And then I can transfer that to a Padlet. So the first thing I did was I made sure that I understood our assigned cases really well, because I just thought otherwise there's no point sort of starting to read this this problem question with no understanding of like what's the law going to be that I need to apply. So I did that first, and then Anne had identified the issues for us, which was so kind. And then I looked at those issues and I thought, okay, what are the sub-issues going to be? And those sub-issues are what makes up the bold questions in each of these boxes. So I sort of did that by thinking for privity especially, it was sort of what are the different avenues that might be argued and what are the elements of each of those. For example, joint primacy being things like, well, is there even evidence? And then things like consideration as well. So I had those.
Sorry, I just interrupting you there because it's really something that's often left out of IRAC type approaches, where actually when you've identified a sub issue and you go, okay, if I'm going to argue that, where's the evidence? Which is something I know Kevin works with you with, but where's the evidence? So
so that was sort of I had this big list of sub issues and sort of related questions that I needed to fill in. And I sort of just worked through the case readings, like my notes from the case readings, as well as the facts from the problem question, to fill out points under each of those sub issues. As well, I was identifying counter arguments throughout, which is sort of these in between boxes that don't have the headings. If you can see, that one there. Which was a part of this task that I actually really enjoyed, because I think it's sort of Emily touched on this as well. It's just realistic to have to consider both sides rather than being forced into arguing one side sort of relentlessly. And I feel like perhaps sometimes that you can get a bit blind doing that, if that makes sense. Like you just have that tunnel vision, and it's realistic to sort of consider, okay, what's the other side going to argue and how can I argue against that? So I enjoyed doing that. Just trying to think what else I did. The blue boxes they're the places where I use the additional cases. And I just wanted to make it really clear to the marker that like that's where those were. Similar to what Emily said, I tried to incorporate the rules into my actual application. So for example, over here where it says, can estoppel by convention overcome this issue? I would sort of like have quite a concise statement that actually used the language from the case law to show how I was applying it. And that was a great way, I think, for me to sort of squash down all of the content that I wanted to include. Just trying to think. Not sure if there's anything else. One thing that did help me as well was having someone look at my mind map before I submitted them. And I sort of said to them, okay, you need to tell me that you can follow along exactly where I'm going. And they were able to do that. So that was good as well. That was really helpful that someone from like a non-legal background could understand what I was trying to say.
That's great.
Yeah.
You did that too, Emily?
Yeah, I got my mum to look at it, because the first time I did it, it was a mess. And then I went back in and I had to redo the arrows to try to make it make sense, because I was like, if I can't follow it and she can't follow it, then like the marker's not going to have a chance.
It's fantastic to hear that you did that, because it's exactly right. Like you actually need to have somebody else look at your work, and it doesn't matter how experienced or, you know, how good you are at problem solving. It's actually you need somebody to stand back and hear your arguments and let you know whether they make sense, because they make sense inside your head.
Yeah, I always get tunnel vision with these things. Like I just
I would say that.
I think
sorry.
Everything I wanted to say.
Yeah, I was just thinking that it's really lovely to hear both of you talk about that. The pleasure almost that you get in being given the freedom to look at the counter argument, because where I sort of really cotton on to just how tunnel vision and just forgetting that of course law students who are asked to solve a problem question for a client tend to get that tunnel vision and tend to miss out on a lot of things because of that. was working with students who were mooting, and of course they often had to do appellant submissions and then respondent submissions, and you'd work with them on their appellant submissions, and they're like, oh, we've got this, we've got such a great case, and we've got all these really good arguments. And then a week later you'd be in the same room with them and they would be going, oh my gosh, this is going to win, And so seeing it with a different set of lenses and just how different that experience would be is sort of fun, because I think that's such an awakening when you realize that both sides think they've got the winning argument.
Yeah.
Okay, no, that's fantastic. Thank you both so much. I'm just going to stop sharing and stop recording